Good afternoon, everyone. Thank you for joining Anne Marie and myself, Merritt Green, today for our 20 questions regarding estate planning. Anne Marie, do you want to say hello?
Hello, everyone. Welcome. Thanks for joining us.
Great. So we'll take this. We have 20 questions that we'll be answering that are most common for clients. But if you have additional questions, please use your the questions tab. And we will try to address those. We will plan that this webinar will take between 45 minutes and 60 minutes, but we, come hell or high water, will be done by 1 o'clock. So you can plan your time accordingly. So with that, let us get going. Number one, just quickly about General Counsel PC. The firm was founded in 2004. We represent businesses, nonprofits, and individuals throughout the DC metropolitan area and throughout the country. We have 6 practice areas. We represent clients in business law, so that's contracts, M&A arrangements, buying and selling businesses outside general counsel. And we do a lot of that for a lot of nonprofits also, where we're helping with leases and contracts and things along those lines. We do a lot of employment law, so day-to-day employment counsel, hiring, firing, non-compete agreements, employee handbooks, everything that you can possibly imagine. We work and represent government contractors. So that's teaming agreements, subcontract agreements, bid protest, and again, anything involving government contractors. We represent clients in a lot of state, federal court litigation throughout the DC area and around the country. We also do a lot of arbitration and other dispute resolution. We have a divorce, custody, and family law practice. And if you're interested, we're having a webinar on that next week. And then finally, last but not least, we have our estate planning and asset protection practice that is led by Anne Marie and that we will talk about today. So with that, Anne Marie, do you want to give a little introduction of yourself?
Absolutely. So I'm Anne Marie Murzin. I specialize solely in estate planning, working with families, single people, parents, those people who are married or unmarried, divorced, even remarried. No, there's no one size fits all for estate planning when it comes to families, especially. We create a will or trust-based estate plans that meets specific client goals and make sure that you can take care of loved ones if anything unfortunate occurs. So as part of the webinar and the form, we offered consult. So if any of the questions are not answered that you have that apply specifically to you, because as I said, one size doesn't fit all, feel free to schedule a consult with me. I look forward to talking with you personally.
Wonderful. And then we also have some reviews here that were provided by just 2 of Anne Marie's clients recently. There are a whole bunch more on the website under her bio. So please consider reading that if you need any information on Anne Marie. And with that, let's go ahead and jump into the presentation. So number 1, I don't have an estate plan. Why do I need estate planning? What does estate planning mean?
Well, a good definition of estate planning is really simply making decisions about what will happen to you when you die. And ideally, if it's done right, also what will happen to your body. Best practices sometimes include what happens when you're incapacitated. So if you happen to not be able to communicate, you want to nominate someone who can communicate on your behalf about, to make decisions about your finances, but also healthcare decisions.
Mm-hmm. So estate planning is a lot more than just getting a will, and even if you're single and you don't have any children, you almost still need to do estate planning, even if it's just getting a power of an attorney or taking care of some simple things.
Right. And it doesn't take that long. People think that, estate planning is this big, long, drawn-out thing. It can be very specific and complicated, but also, if you just take a few hours to, make a basic estate plan, you're saving your loved ones and even yourself, a lot of time and stress.
And even just looking at some of the things we've done for clients recently, it can be as simple as doing a power of an attorney. We had a client who was, going out of the country, and they wanted to make sure that someone was available to take care of things, so we did a power of an attorney. Or It's things along those lines. So that leads us into number 2. What are some of the most common tools used in estate planning?
Well, I mentioned already, there's a will-based estate plan and a trust-based estate plan, then a combination of all of those. There is a power of attorney is usually also part of the estate plan. We recommend an advanced healthcare directive. Sometimes people refer to that as a living will or healthcare proxy. If you have minor children, it's a good idea to have a guardian nomination, nominating temporary and permanent guardians if you can't be available to help them when needed or if there's an accident. We also have a type of privacy waiver that we include, and that addresses social media, access to medical records, sometimes can be used to access passwords, if you are not able to give that to access a particular account. And then it's all been awkward to talk about, but also final disposition, a form that kind of indicates what you'd want to happen, whether you want to be cremated or buried, whether you want a memorial service or you don't want to do any of that or leave it up to your family. So that's included as well. We also recommend a personal property memorandum, so you can list specific items that you want to go to certain people, things that, a ring that's been in the family or a baseball card collection or anything along those lines. You can do that as well with an estate plan.
So there are really just a lot of tools that are available. And oftentimes when I talk to clients and I sort of think about our job as an attorneys, our job is really to think about first, all the what ifs, thinking about everyone's particular circumstances. What if, what could happen, if you're hit by a bus? And I often will use the example of getting hit by a bus, because hopefully it's never going to happen to anyone, although we all will pass away at some point, but hopefully none of us will get hit by a bus. So what happens if you're hit by a bus? Are you prepared? Do you have a child with special needs? Do you have that baseball card collection? Do you have, an asset that you want to pass on to someone? Do you have, a life estate you want to give to a grandparent to keep living in a house? All the what ifs. And that's our job, is to get all that information from you and use the tools to put a plan in place that allows our client who's doing the estate planning to plan what they want to happen in the future. It really allows the client, through these estate planning tools, to be in charge, to have input on what happens to their assets, to their medical directive questions, or even to their body when they pass away. So,
and really along those lines about you're saying who's in charge, usually the people who sign on to this webinar are usually the responsible ones, the ones that handle things for the other members of the family. And when you're not available for whatever reason, whether you happen to be out of the country because of COVID, or you had a quarantine, or temporarily you're incapacitated and you can't handle your normal responsibilities, who do you trust to step in, or who can you rely on in case of emergency to handle the things that you do day to day, in your life and your family, in your responsibilities, but also, maybe your business that you run or in your job, who can step in and take over when you're not available.
And that's why, and we'll move on momentarily, why everyone should sort of consider estate planning, whether you're, 25 and single, or 90 and married with, 50 grandkids. Obviously, as you have more assets and more dependents, the estate planning can become a lot more complicated. And we'll talk about some of that. But if you're worth $100 million, there's a lot more tax planning and other things that we're doing for you than someone that is perhaps just, has a net worth of $500,000 with another $500,000 life insurance. They're different processes, but both individuals, both families need to do the estate planning. So, what is probate, and why should I care?
Well, probate is an administrative procedure where a court attempts to interpret your wishes that you put down in your will, and sometimes a trust, regarding your assets, your debt. Sometimes it addresses taxes, and the court manages any conflicts that may arise. In probate, if you have minor children, the court can also appoint guardians and communicate usually with a family member and an attorney to file documents, to distribute assets, and to resolve all the issues related to your estate.
So, I guess if someone passes away, probably more, but there are probably three basic situations that can occur in that. So number one, someone dies intestate, meaning that they don't have a will. Number two, they have a will. And then number three, they have a trust. So just quickly, what happens in each of those circumstances and how are they different, and how do you as an estate planning attorney help clients pick which direction they want to go?
Yeah, people don't realize that if you don't have an estate plan, the government, the state that you live in has a plan for you, and they just base that on traditional families and what you would traditionally want. It only includes blood-related relatives. So if you pass away without a will and you're one of those people who has, a blended family, or you're not married, those type of situations, then your situation is a little bit more complicated when you die intestate, because the laws have not updated to our modern version of what families are now, for the most part.
So a judge decides what happens, and it needs to go through a potentially contested court process, where it costs lawyers and it's potentially time-consuming, expensive, and difficult.
And people can testify and have hearings about what you would have wanted, what they recalled. If someone said, "Oh, I remember them writing something down," they could introduce evidence in that regard. You hear about that. They wrote something on a scrap of paper. So those are actually real things. If people have a large estate, happen to celebrities, sometimes they just they rise to fame and they don't take the time to do an estate plan, and a lot of their money ends up going to attorney's fees, to resolve all of that. So if you do have time to at least get a simple will, that would be much better than dying intestate, because that just involves lots of potential courtroom drama.
All right, so number two is you have a will. So what happens in that regard?
So if you have a will is, again, instructions to the court about what you want to be done. So a will would be presented to the judge. The judge would review it and make sure that it meets all the requirements, has witnesses, notary, etc., just to make sure it's authentic. And then they go through and they appoint a personal representative, sometimes called an executor, and that personal representative is tasked to marshal all your assets, basically do an inventory of what is there. Sometimes an appraisal is ordered if you have not waived that, to see the value of all the different items. It ends up being a potentially time-consuming process, depending on what your assets are and how organized you are and how the will is written. Best practices for a will includes waiving an appraisal, waiving hearings, things like that, to reduce the potential length of the process. But if you just have something that you just wrote yourself or printed off the internet, it actually ends up costing more money in the long run, because you're encouraging judicial intervention versus handling things privately.
So if you have a simple will, or even perhaps a complicated will, still need to go through probate, but the person who drafted the will, whether it's a husband, wife, or whether it's someone individually, they at least get to provide some direction. Absolutely. And then finally, with a trust, can you avoid probate? What's the advantage of a trust?
Yes, we're probably going to address this a little bit more detail later, but generally a trust avoids probate if that's the intent of it. It stays private, whereas a will is public through the court. And a trust is actually in effect during your lifetime, not just when you pass away. So a will, like I said, is only when you die, and then a trust is during your lifetime. It also covers when you are incapacitated, if you happen to be in a coma or just temporarily not available, and then when you pass away. So a trust is just a different way of handling your estate during your lifetime and also when you pass away.
Okay, so I think that's a really good distinction, and why oftentimes a trust could be really beneficial is it's sort of a lifetime transfer, so you really can avoid probate, at least for the assets that are within that trust. All right, we won't spend as much time on individual questions going forward to make sure we go through it, but I thought that was worthwhile to sort of get really good basics in place for everyone. So number 4, what is a medical directive and why do I need one?
Medical directive, people, talk about a lot, but sometimes they don't actually, bite the bullet and just get it done. And it's really not that hard to do. It's sometimes called a living will or advanced healthcare directive. And all it is nominating someone to communicate what your health wishes would be, your medical requests would be if you can't communicate yourself. So it's not like you're handing over your, your rights to anyone at any time. It's just if you can't communicate, like you can't even blink your eyes or you can't even nod yes or no as to what you want. And this addresses, the feeding tube, the artificial respiration, and then it can even cover whether you're open to experimental treatment or you only want proven treatment. And, let's just say it's experimental, how long you want to try that. So, maybe you're one of those people who, you want to pull out all stops, you want to live and, you want to give it a good shot. Or maybe you're one of the people that says, no, just, I want to just pull the plug. I'm good. So you're able to communicate that through this medical directive about what you might want. And then you have different scenarios in there. And so people can understand if you can't communicate what you would have wanted.
So again, it's putting the person in control of their life and decisions impacting their life. And I assume it also might cover organ donation?
Yep, absolutely. Covers organ donation. And then in that regard, would you want to, how long would you like to be, on life support or life sustaining treatment while they wait for a donor? Do you want to wait for two days, 3 days? What is good for your family? Making sure that the insurance provisions, if you're going to be an organ donor, making sure that doesn't just come to your cost, that it goes to the person, the recipient who's going to receive the organ and doesn't impact you at all, that it's a gift. So you can make all those rights clear in the Advanced Healthcare Directive.
Yeah. All right, number 5, what is a power of attorney and is it important to have?
Right. Well, we touched on this a little bit earlier, but simply a power of attorney is a document that lets someone else stand in your shoes to take action, to communicate on your behalf, to make decisions, to sign documents. And there's different types of powers of attorney. One is immediate. So as soon as you sign it, it's effective immediately. Sometimes people like this because in case, let's just say a husband-wife scenario, husband goes out of town, the wife can still, sign documents, different things when, one of the spouses is not available. Or business owners, they also like to have someone else who is in charge if they happen to be unavailable. So that's a good idea. But other people prefer to have a springing power of attorney. So in a power of attorney that takes only effect in case of emergency. And you can outline, what those requirements is and what an emergency means to you. And you can have that address things, like I mentioned, bank accounts or making decisions, but you could also have it address things like communicating with the IRS or communicating with the US Post Office. So you can actually, receive packages if someone is incapacitated or not available. So there's different types, but essentially it allows someone else to stand in your shoes and be you while you can't.
Gotcha. And we've already addressed this a little bit, but what's the difference between a will and a trust? If to the extent that we haven't already talked about
it. Right. No, I understand. Well, a will and a trust both can address tax provisions and also what you want, how do you want debt to be handled? Because sometimes, if you pass away, you might have loans, you might have credit cards, you might have different things that don't disappear. So you can also have not just handle your assets, but it can also address your debt. And how you want taxes to be handled. Do you want to cover the taxes that may be incurred on a gift that you're giving someone, or do they handle those taxes themselves once they receive the gift? So you can make those decisions.
And you make those within a trust.
Mm-hmm.
Okay. Yeah, and what really rang home for me earlier was a will happens after you pass away, a trust can happen while you're alive.
Mm-hmm.
So I've heard of a pour over will. What is that?
Just to go back real quick on the trust, I just wanted to mention, in the trust, you can create certain conditions for inheritance differently than in a will. So you can specify who can inherit, when and for what purpose. Can your children inherit when they're 21, when they're 35? Do you want them to graduate from college before they inherit? And trust can also be, special needs trust, only for certain medical purposes or to make someone's life more comfortable. So there's just a lot of different conditions you can put in there. You can essentially add your values more in a trust versus a will, because you have all these different conditions that can take effect.
Great. All right. Pour over will. And I know we're going to get more into trust in question number 9.
Okay. A pour over will is usually executed in conjunction with a trust. And essentially what it is if you have a trust, you associate property with the trust. So let's just say you have a house and you want to put the house into the trust. And so the house is owned by your family trust, for example. But then you decide to buy a condo, in Florida, and you didn't have a chance to put the condo into the trust. So a pour over will takes all the assets that you just didn't have a chance to put in the name of the trust for whatever reason and pours them over to the trust. It says, Judge, so sorry, these few assets we didn't get in there. We're just use this as an administrative mechanism to put everything in my trust, and then we'll go from there. And usually that is something that's pretty streamlined and expected.
Excellent. All right, we do have a question here, which is a medical power of attorney or a medical directive specific to a state? So if I move to another state, do I need to redo the medical directive?
Well, I do suggest redoing the medical directive, every, so often, because your opinions change, especially now during COVID. People are looking back at their prior medical directive pre-COVID, and, their opinions have changed because of the different treatment. For example, they have treatment where you have to be in a medically induced coma for a period of time to allow your body to fight off this particular, illness and then come back. So, maybe you wanted to pull the plug, but you wouldn't necessarily want to do that if you're in a medically induced coma versus one from an accident. So in general, best practices, it's good, now that we know more after the situation, to update your medical healthcare directive. But the good news is, while each state does have separate laws regarding the healthcare directive and medical power of attorney, so it is good to look at that for your particular state. The federal government all across the country also has uniform laws. And so if something happened and you happen to have a healthcare directive from another state, the courts and also the medical facility is going to do the best they can to honor your intentions, because really that's what we want in our country. People are individual and they want to honor, what someone has already memorialized. So they would do the best they could to interpret it. Just because it's from another state doesn't mean it's automatically void.
So if you have something from Virginia and then you move to North Carolina, you probably don't necessarily need to redo it instantly upon moving, or it's not going to be ineffective. Although you could have a scenario where, and I'm trying to recall whether or not euthanasia is legal in any state. I almost want to think it is legal in Washington or Oregon.
Mm-hmm.
And if you have a medical directive that allows that, and then you move to a state that does not allow it, that would be an interesting scenario, and it's far beyond the scope of this webinar. But have you ever dealt with that situation?
No, I haven't dealt with that situation, but I guess your point, though, is that people could disagree about your healthcare directive. So you could have something written down, and you could have maybe your family members who think, oh, no, they said this to me, or oh, no, you said this to me. And the document is a way, if it's, witnessed and notarized, is a way to say, no, this is what my intentions are, versus what people are saying. So it is really good. You're ahead of the game if you've already had a healthcare directive or a medical power of attorney, written down about what you want, and it reduces family conflict. But yeah, that's an interesting point. We'll have to look into that later.
Yeah, if it's legal in one state but not legal in another state, I imagine in Virginia they might not enforce a medical directive that calls for euthanasia.
Mm-hmm.
Number 9, and just to reiterate, and this is something I'm sure Anne-Marie tells people all the time, having a lot of these documents, you need to make sure you share them with people. So, if you have a medical directive, make sure that, you have a copy and your children and your spouse have copies, and maybe there's another copy on the internet somewhere.
Or you can upload it to a lot of these, your primary care physician has portals now. If there's a specialist you go to, they have portals. You can upload it, to that particular system, so they have it there.
Excellent. Why do I need to do estate plan? Why don't I just simply buy some life insurance?
Well, life insurance is not a bad idea, especially if people have debt. Sometimes it's a good idea, a good vehicle to cover your debt. So when you pass away, people are not left scrambling. But it's really,
or if you have young children and know that you're gonna, you're 35 and you have young children, you want to make sure that you have money for their college education or something else.
100%. Yep, absolutely. Making sure that people that are dependent on you have a way to just continue their life. They're going to have the stress of not having you available, but if you can take out some of the financial stress, that would be helpful. And just as a note, we don't offer, life insurance. We're not life insurance agents or anything. We're just saying generally it's a good idea to think about, finances after you pass away if you have debt. But life insurance is just a piece of the puzzle. It doesn't cover, what happens for the most time. We have really good health care. People don't necessarily pass away right away. More often than not, they're incapacitated for a period of time. You're disabled for a period of time. And so you have to make sure that your estate plan also covers when you are incapacitated, not just when you pass away.
Well, and also life insurance might be nice. You have a life insurance and you have a beneficiary of your spouse.
Mm-hmm.
Well, what happens if you and your spouse, you go back to my standby, are both hit by a bus at the same time? So your beneficiary is your spouse, you're both hit at the same time, and you don't have a will. So then everything is thrown into intestate succession, and the judge decides, pursuant to your state law, how those proceeds are gone or distributed. And maybe you don't have any children, so they go to your siblings or your parents, or you don't have control. So having life insurance is really not an excuse or a reason not to do estate planning. It's another tool that should be utilized as part of the process.
Sure.
And Anne-Marie works, with most of our clients when we're doing estate planning. We'll work with their financial planner as part of the process.
Right.
All right, here we are, number 9. As I said, what are some of the benefits of using a trust? And there are at least like 20 different types of trust, if not more.
Oh yeah, there's a lot of different types of trusts. People often hear about the special needs trust. There's Medicaid trust. There's retirement trust. There's grantor trust. All different types of trusts. But I'll just break down the two main that you hear often. There's a revocable trust and an irrevocable trust. So a revocable trust is exactly like it sounds, that you can put something into a trust, let's just say the house, like I mentioned before, or you can even put, jewelry, personal property, a car, bank accounts into a trust. But then a revocable trust allows you to take it back out. So even if you put it in, you can still take it out during your lifetime. So it's not stuck in there. It's not fixed. It's flexible. And then the other type of trust generally is an irrevocable trust. And that's the type of trust where you put something in it, but you can't take it out except for specific purposes that are outlined within the trust. There's a life insurance trust. That's the type I think sometimes we were referring to before. But there's also grantor trusts that are charitable trusts. So there's a whole, it runs the gamut, but overall, trusts are a little bit more complicated, I guess, on the front end, you can say, to draft and to write, but it saves you time in the long run because you're not paying anything on the back end. It's effective during your lifetime and you don't have to go to court. It keeps things private, and it can have some tax benefits.
Yeah, and I think along those lines, the use of trust provides a lot more control because there's a lot more flexibility in what can be done. So if you want to have a spendthrift trust, you have a child that perhaps had drug issues or otherwise, has had debt issues, or perhaps had to file bankruptcy and is going to have debtors coming after them, you can set up a spendthrift trust, and that could probably be done as a revocable trust. But then for tax planning purposes, oftentimes you'll want to set up an irrevocable trust because the transfer is being made and it's irrevocable. So the tax implications often occur at that point. And oftentimes, for tax purposes, you'll be doing more irrevocable trust than revocable trust.
And the reason that is, if you just think about it, it makes sense. If you're giving up some control by, putting something in a trust that you don't have full control over, then you get something back for giving up control. What you get back is some of the tax benefits. Versus a revocable trust, you still have full power and control over that. And so you're not giving anything up, so you don't get anything back.
Yeah. And that's how you can really achieve some of the tax savings. And, you'll hear the folks with, larger estates. One of my favorites is always the dynasty trust, and I think that's a mechanism to keep wealth in a family, and it's generation skipping trust, and things along those lines. So there are all sorts of tools, and again, it depends on the particular circumstances of the person. Someone who has a net worth of only $2 million probably isn't doing a dynasty trust or generation skipping trust because there won't be the tax advantages to it.
But even smaller states can have different conditions on it. You can say in a trust, for example, whether it's revocable or irrevocable, that someone can't get the money unless they have a full-time job or unless they've graduated from college, or maybe you want to encourage them to have a trade or be an entrepreneur, but before they open, you get money for seed money to start their own business, then they have to have at least a business plan and show that to the trustee. So there's a way to put your values in the trust and make sure that your hard-earned money is going to different places where you think it would be well spent.
Mm-hmm. No, absolutely. Just recently we had a client who wanted to help out an older family member, and we took some of the assets of that older family member, put it into a trust, and made the younger family member the trustee, and just to protect the assets and protect the family member. So it really can be used in different ways. Mm-hmm. All right, number 10. I'm single, live in a condo, have some savings, and a retirement account. What should I be doing?
Mm-hmm. First, it's awesome to even ask the question. Many people don't even think about it. They think, oh, I'm single, what's the big deal? But without planning, people often have a hard time finding out what exactly you own. If you're not, if you don't live with someone, if you're not married, people have a hard time sorting everything out. So you still have hard-earned money and things, assets and things that were important to you. And for the condo itself, like, who even has the extra set of keys? That has nothing to do with legal planning. It's just thinking about, what happens next. But first, it's a good idea to have at least the power of attorney. So you're naming someone who can act on your behalf in case of emergency or immediately if you are not able to take action to help yourself for whatever reason. And then it's a good idea to have a will or a trust. Either one would be fine depending on your particular situation. If it's important to you to have your own healthcare decisions, then it would be good to have an advanced healthcare directive or living will. And then the privacy waiver is pretty key because you don't have another family member that's living with you who is aware of the different accounts you have, whether it's on social media or whatever. So privacy waiver is a good idea. And overall, just definitely talk to a family member and friend and let them know, what the plan is in case of emergency. And then update your beneficiaries with your employer or on your retirement account, just to make sure that that is all accurate. Because if they can't get a hold of whoever you listed there, or you no longer, talk to that particular person, then your money is going to go to someone or someplace that you didn't want it to be, or be sucked down with court fees and attorney's fees trying to figure everything out. So if you can untangle it ahead of time and be organized, that would be amazing.
Right. And really is for that single person, it avoids intestate succession. So, perhaps that single person wants all of the money to go to, the girlfriend that they've lived for 10 years, but they're not married, or else they want it to go to their mother and not their brother or sister, or they want it to go to their sister, and not their parents or other people. Again, it's putting yourself in control to make decisions.
And
All
also,
right.
you can name, we didn't really talk too much about charities, but you can name, a particular charity. You can have, 50% go to your family and 50% go to a charity, et cetera, et cetera. And if you do that during your lifetime, there's often benefits, different things that you can be involved with and meet people who have done the same thing and feel the same way as you during your lifetime. So it is wonderful to name a charity ahead of time, and it's a gift that they can count on.
Right. All right. And oftentimes for tax planning, that might be done as an irrevocable trust.
Exactly. Grantor
Number
Trust.
11. My husband and I are separated and likely getting divorced. Should I update my will, consider a trust, or something else?
Absolutely. Call me right away, please. Because usually in this situation, you don't want to have your spouse that you're no longer going to be living your life with making decisions on your behalf. So if you already have an estate plan, you're thinking about separating, or things are just not going the right way, you should definitely, call an attorney and get that updated. And one thing people often don't realize, even if they are married, that your estate plan doesn't have to match your spouse. It doesn't have to be what they call a sweetheart will. Even if you are married, and then if you are separated, or you can have it different. However, the issue comes down to minor children when it is separated and divorced. So it's important to make sure that everyone's on the same page for temporary guardians and permanent guardians if something was going to happen to both of you. In the way we do it, we actually also incorporate the co-parenting plan and the visitation plan, because if one spouse passes away, they still want the other one to allow their children to celebrate Thanksgiving with a certain side of the family, or those holidays that they usually do. So if you incorporate all of those into the estate plan, it keeps things fluid and reduces stress, and honestly, it still puts the children first.
In that regard, you can work with our family law attorney, Joanna Ford, on such matters, who is a huge proponent of having good parental plans, co-parenting agreements. And just quickly on sort of number 11, if husband and wife are separated, something happens, if they don't have a will, intestate succession will go to that spouse. They are still married. The court won't recognize, oh, we're separated. You're still married for those purposes. So you absolutely want to update your will. And I don't think you need to tell your spouse you're doing it. You go and do it yourself, because again, if you pass away, you're hit by that bus while you're in that separation period. You really don't want your ex-spouse, who's now, dating some 23-year-old, to get all of your money, or to get your life insurance or your 401k. That would sort of, you'd be sitting in heaven and be rather annoyed. So you probably want to avoid that.
You have to come down and haunt them.
Absolutely. All right, number 12. My daughter is married. If she predeceases her husband, who has children from a prior marriage, how can we make sure that he does not inherit our money?
Yeah, that's a good one. And people talk about this a lot. If someone passes away, they don't want their family money, their family legacy to go to another family down a whole different bloodline. So that's something you can plan through a will or a trust. And just to throw a nuance, I know we're already like 1240 almost here now. Another nuance is that a will can actually have a trust in it. It's called a testamentary trust. So if certain conditions happen, like this scenario, the court can actually create a trust by court order if certain conditions are met, and then preserve that money for that side of the family. So there's a lot of different ways you can go about it, but you can use the law as a tool to protect against that particular scenario for sure.
And what you often do is setting up trust for life insurance trust. You have more and more blended families. So within those circumstances, one spouse might have, they might have 2 children from the current marriage, but 1 child from the previous marriage. So if they have $1 million of life insurance, they may, either by the requirement of a parental separation agreement with their previous spouse, or just, to set it up, they might want to have 300 going to the 1 child from the previous marriage, and the remaining 700 going to the children from the current marriage. And then the other spouse might do something similar depending on their circumstances. So you can have tools to make that happen.
And another decision that could be made is whether or not you want, if your child happens to pass away, but you have grandchildren, would you want the money to go right to the grandchildren, or would you like that to be spread around and go back into the pot and spread to the other siblings? So you can think about whether you want it to go passed down the line per stirpes, they call it, or per capita by heads, who is survived on the next line down after you pass away.
Well, that's interesting. If you have it set up in a trust and you don't like your daughter's husband, you could almost have the money in trust and have it just sit in the trust, for 20 years until your grandchildren are, out of college, and perhaps use some of it to pay for their college because the husband's a deadbeat and doesn't have the money, whatever the circumstances are. Again, it puts the person in control and can make those plans. Number 13, grandson's great, but he struggled with addiction and debt for several years. What can we do? I know we mentioned something called a spendthrift trust.
Right. It's sort of like a version of a special needs trust, a spendthrift trust, but it protects the assets. And if the person, let's just say the grandson or the son was, made financially immature or, irresponsible decisions or, struggles with addiction, you don't want to be able to give them, access to all the assets all at once. So the trustee in the trust can distribute that when and if it's appropriate. Sometimes they require proof of, not being an addict for whatever reason, being involved in a rehab. But overall, you can just make sure that the money is used for the person's benefit, but would not be abused. And there's ways to kind of write that in and consider all the different contingencies that might occur. So a trust is a good way to do it. But again, you can do a trust within a will. So you could say if there's a particular scenario, you can direct your executor or your personal representative to ask the court in this particular situation to create a trust because you're aware of this, unfortunate situation that this particular beneficiary is involved in, and they can protect it that way. So there's two ways to go.
Yeah, and in that circumstance, let's say that grandson goes out and gets in a drunk driving accident and kills, someone. If you have the money and then they bring a lawsuit and get a, $2 million judgment against the grandson, if the money's held in a spendthrift trust, they can't get access to that money, correct?
Yep, and it's protected under different circumstances, for sure.
So that's pretty important. Number 14, we recently purchased a home. Should we update our estate planning? And let's say, you moved from one state to another, or even you're in the same state.
Yeah, absolutely. It's very important to update the estate plan, especially if you already have an estate plan, you have a trust-based estate plan. So if you move to another state, it's important to do an amendment to that trust or, revisit it and see if you need to do a different type of trust. People often don't realize that when you create a trust, that's great, but it's only the first step. It's like the part A. The part B is funding the trust. So if you move to another state and buy a different, property, you actually have to put that property into your trust, whatever state that might be. So that's something that you can update. But if you have a will-based plan, it's also good if you move to another state to update it just to make sure that it meets the requirements of your state. But again, note there's uniform laws across the whole country. So just because you move, don't think that, oh no, this is not going to be effective at all. It just might take a little bit more effort to get it probated.
How important is it for individuals to put their property within a trust? I recently saw a real estate transaction and the sellers were not selling individually. It was their trust that was selling the property. How important is it to have the property in a trust?
It's very important because if you don't have anything in the trust, then the trust has nothing to operate with. It's almost like having an empty box. So you have all these great provisions. You thought through all these different conditions. It's okay if someone is a plumber, doesn't have to go to college, all these different provisions. But if there's nothing to distribute, if there's nothing in that trust that you created, then all of that is for naught. One other thing about real estate is it's very important to have a bank account associated with a trust because like you were saying that the trust was selling a property. Well, they can't actually get the proceeds from the sale unless it's deposited into an account in the name of the trust. So everything has to be coordinated. And, that's one thing we do here is we do the, focusing on your client goals and making sure that we, provide for your loved ones in the way that you want, but also helping you get organized. So if anything happens and any contingencies, things are streamlined.
Great. Very good. I know we talked about this a little bit, but I'm a divorced dad with 2 kids from my first marriage, now remarried, expecting another child with my second wife, although I hate the term second wife, with my wife. How can I protect all of them except my ex-spouse?
Mm-hmm. Well, there are disinheritance provisions that you can put in a will, or a trust. You can specifically say, this is my current wife, these are my children, these are the people I consider my family, and anyone else should not inherit. So you can just bring it to if you have a will, you bring it to the court's attention right up front. And if you have a trust, you just outline, who you consider to be your family. And either way, you can determine, who you want to receive what and about how much. So, everyone should get 1/5, or this person should get, 1/2, or however you want to determine it. But if you just do a little bit of planning, like 1 or 2 hours of planning, it'll actually save so much in the long run, especially in the blended family situation. It'll make everyone feel like things are fair, and that's important too.
And I think in the blended family circumstance, perhaps even, I think it's important for every family to do estate planning, but in that blended family, it's probably even a little bit more important, just so you're outlining things so there isn't confusion and you don't have, stepchildren, arguing and battling with, children that were born from mom and dad who just passed away, whatever the circumstances are.
Mm-hmm.
All right, I have a special needs child. What estate planning options and tools do I have?
Well, we mentioned this before, the special needs trust, but I'll talk about it a little bit more in detail. So a special needs trust identifies a certain amount of money to be used to take care of that child. And so whether they are used to a certain type of therapy, whether you can even specify, that they like this particular music, they like this particular park, and they like to go to walk in this particular park. You can be as specific or general as possible, but essentially it sets aside money for your special needs child in case, anything happens to you and you can't provide them on a regular basis, or even if you have them in a facility, that money can be used and can protect it from, or have the person still be able to be eligible for government benefits. So it has some tax benefits as well. So, but it's definitely something you should seek counsel on and consider everyone's individual situation, because that is a little bit different than the traditional trust.
Yeah. All right. Number 17, I read some trusts are used for tax planning purposes. How common is that?
It's actually very common. The federal state tax exemption is very high now. It's 12 million. So it's supposed to go back down to 5 million in 2025. So again, this is like for a different scenario, very specific family. But it's a good idea to consider Grantor Trust. It could be one that you actually just live off the income on an annual basis, and then the principal is gifted to someone in the future. It could be another one where it varies over the year, and there's just all different types of them. So it's important to definitely get some advice on that, but it can be used as a great tool to protect your hard-earned money that you've accumulated over these years.
Mm-hmm. All right, number 18, I plan to move when I retire. Should I just wait to do my estate planning after I move?
Definitely not, because you can do it. I guess that you can do it now. It's more important to do now to make sure that your wishes are memorialized in some way and your family knows what you want. And then when you retire, hopefully the attorney that you use has thought ahead of time and is aware that you might retire and move somewhere, and wrote it in a way that it's fluid and it actually addresses those situations. There might be an amendment or two that's necessary based on the state that you move to, but you probably wouldn't have to do a whole another full-blown estate plan since you've already done it in the first place. So the sooner you do it, the better, not just to make sure that your wishes are addressed.
Yeah, it's again, you want to avoid the what ifs. You want to have control and planning. You never know if you're going to get hit by a bus. So, don't wait to move to North Carolina to do your estate planning. You want to get it done now. And you might have to retitle property in the trust, for example, if you buy a new house, but otherwise, it's
And it's always good to update your estate plan, when you retire, because obviously the laws change and the tax laws change. We can only tell you what the law is right now. So, a good rule of thumb is, every 3 years to check your estate plan.
Well, circumstances change. Your one of your children might get divorced, or something else might happen. You might decide that you really don't like your aunt, Velma anymore, or whatever the circumstances are. Number 19, I'm a small business owner and my family depends on my income. Is there a way to protect them with estate planning or other planning if anything unfortunate happens to me?
100%. And it's such a good idea, especially we have these people depending on you. So a power of attorney is terrific for a small business owner to name someone who can, manage things in case anything happens, even temporarily to you. It doesn't have to be permanent. And then a trust or will-based estate plan is something that you should definitely consider. And we mentioned life insurance before, but there's also different types of insurance for business owners to consider. Even though we don't offer insurance, but just another piece of the puzzle in addition to using the law as a tool to protect your business and to protect your loved ones.
Very good. And the last question, and we're finishing right on time with even a few minutes to spare. This is a nice softball for Anne-Marie. And you're helping clients with estate planning. What's the most important advice you can give them?
The most important advice really is to just take some time to think about this. And obviously you're doing the right thing by learning about estate planning here today. But if you take 1 or 2 hours at the most, to do some type of estate planning, it's going to save your family members, your friends, hours of time and definitely your hard-earned money if you make some decisions and structure things ahead of time versus waiting to an emergency. So it doesn't have to be overwhelming, doesn't have to be complicated, and a little goes a long way.
And it's also not that expensive. And I guess the only thing I would add is, you don't delay almost. You want to make some of these decisions and get some of the tools in place, sooner than later, because you really never know what happens. And, as lawyers, we hate hearing the stories of, well, they had met with an estate planning attorney, but never actually did anything. Or they never signed the documents. I know someone very well who he and his wife were doing estate planning and they never signed the documents, and the wife tragically passed away in an accident, and it really left them in a difficult situation. Not only that the estate planning documents were not done, but they never signed some life insurance policies also and had young children. So it's good just to do the planning.
A lot of people told me that they wanted to come to this webinar just because they had a change in their life. So they just had a new baby, or they're moving, but other people generally said that I want this to be the year that I finally get this done. I've been talking about it and talking about it. And so it isn't that complicated to get it done. And I'd welcome the opportunity to answer your specific questions or, meet with you, just have a quick conversation so you can, understand what your options are. We'll tell you what the real deal is. And, we don't make a mountain out of a molehill here. We just want to make sure that everyone is protected and can use the legal tools that are available to make your life easier during your lifetime, and then, your friends and family if and when anything happens to you.
And I know we're about out of time. There are 1 or 2 other additional questions. Someone asked about some of the cost. I would recommend that you just send an email to Anne-Marie at the email that you see here, and she can give you an idea of the cost. It really depends on your particular circumstances. There's another question about how a trust can save on federal income taxes. Again, I would suggest sending an email to Anne-Marie, but as we talked about, lots of times you're transferring assets into the trust during your lifetime, and you're you no longer have possession of those assets. If it's an irrevocable trust, therefore you can minimize the taxation impact through that. And I'm sure it's a lot more complicated than I just suggested, and Anne Marie can go into more detail at another time. And
True.
then finally,
but also a trust saves time, because you actually don't have to hire an attorney if the trust is written the right way. Things stay private, and assets that are it's seamless. Versus a will, it might cost less at the outset, but you actually have to hire an attorney, pay them by the hour to probate the will. So with a will, you're paying less on the front end, more on the back end. Whereas a trust, you pay a little bit more on the front end, but there isn't usually a cost on the back end.
yeah. And the final thing I'll say is I know a number of folks that signed up today have requested to have free consultations with Anne Marie. I trust you'll make that offer available to anyone who participate in. If they want to send an email to you, you'll be happy to spend 10 minutes with them, give or take, as consultations or talk through some options for them.
Absolutely, and just point them in the right direction. Sometimes you have specific scenarios that we didn't address here, and I'd have to listen to that and give you my thoughts.
Great. All right. Well, with that, thank you, everyone. Thank you, Anne Marie. And if you have any questions, please do not hesitate to contact us, not only for estate planning, but for other areas of law also. We'd be happy to help you out. Thank you so much.
Bye.